Hello, everyone, and welcome to One Civil Law. And for today's story, we are turning back a couple days to rewatch the opening statements in the ongoing Doomsday cult mom murder case that is Arizona versus Lori Daybell. You may remember Daybell because she goes by many different names. She's got like 6 first names and 3 last names or something. It's hard to keep track. She goes by many different names. But she was previously involved in a cult murder case relating to the murder of her own children in the great state of Utah, and things didn't really go well for her there, being sentenced to life imprisonment. And she has now been shipped off to Arizona because Arizona would like a piece of her relating to some crimes that she may have done. And Miss Vallow has decided to represent herself, which, you know, to be fair to Miss Vallow at this point, she really doesn't have anything to lose. She's already serving life in Utah. So, you know, why not? I mean, it really can't get much worse. So she gets her moment on the stage. And unlike Utah, we actually have video. We didn't have that. We had some audio before, but we didn't have videos. We didn't get to see Miss Daybell. It was very, very disappointing for us all. But now we get to view Miss Daybell in all of her glory. So we're going to watch the opening arguments by the prosecutor and Miss Daybell herself to see what's kind of going on in this case. So let's go ahead and get started with that.
So I'm going to need you to stay close to me the next couple of days. Mel, too. She can't go to Utah. They're planking some kind of intervention, but want Mel out of the way, so I'm left alone. I need to come get the stuff at your house tomorrow and secure it. Lots to do. Thanks for standing by me. It's all coming to a head this week. I will be like Nephi, I am told, and so will you. Lori Daybell, the woman seated over here, wrote this to her brother Alex Cox on July 9th of 2019, 2 days before they killed Charles Vallow. But to understand why this is so meaningful, why this is relevant, you have to understand the context.
Tell me.
So let's talk about it.
Teach me the context.
In July of 2019, Lori Vallow was married to Charles Vallow. Lori Vallow lived here in Arizona, Chandler. Charles Vallow lived in Texas. In July of 2019, Lori Daybell was Lori Vallow, married.
Again, she goes by many names. I've forgotten how many different names she has, but it's like 6 first names and 3 last names. She goes by many different names, but yeah, that's one of her names, I guess.
To Charles Vallow. In July of 2019, Lori Vallow wanted to be Lori Daybell, wife of Chad Daybell. And in July of 2019, Lori Vallow wanted to keep the same lifestyle that she had with Charles. And she could get all of this if Charles was dead. She could marry Chad Daybell and become Lori Daybell. She would get a $1 million life insurance policy from Charles Vallow. She would get Social Security for herself and their son, JJ, as a child of a dead spouse. And all of this would be true if Charles Vallow was dead. So what about Nephi? Well, Lori Vallow, Chad Daybell, and Alex Cox all believed that those who disagreed with them were dark, possessed by evil spirits.
Yes, we've
sometimes called Z's or zombies. Sometimes they had names for these evil spirits, like Ned.
Ned?
Lori, Chad, and Alex used religion, the Church of Jesus Christ of Latter-day Saints, and a story of Nephi, a prophet, who was directed by the Holy Spirit to kill Laban, to obtain brass plates and secure the long-term prosperity of Nephi's descendants.
I don't know this story.
This religion and the story of Nephi as justification to kill Charles Vallow, just like Nephi killed Laban. On July 9th of 2019, Lori Vallow invoked Nephi when she messaged Alex to provide them with that religious authority to kill Charles. After months of trying to get rid of him, they were finally ready to be like Nephi.
Okay.
So how did this begin? We go back to 2018. Lori Vallow met Chad Daybell. You will learn that in November of 2018, that Chad Daybell came to Arizona for a Preparing the People conference. And he and others stayed at Lori and Chad's house. Charles was actually out of town with JJ. Lori and Chad acted as if there was nothing between them, but nothing could be further from the truth. By January of 2019, Lori Vallow claimed that Charles Vallow was possessed by an evil spirit that she called Ned.
Ned.
You will see text messages where Lori and Alex refer to him as Ned.
I find it mildly hilarious that the demon spawn possessing them is called Ned. You would think that the demon spawn would have some sort of, more grandiose name, either unspeakable demonic or maybe some old school Assyrian Aramaic or something. But apparently the demon is just called Ned. That's funny.
During this trial, you're going to hear from some women who initially were close in Lori's circle. These women will tell you they met her through the Preparing the People conference. They are spiritual women within the LDS church. And initially they found Lori's spirituality infectious. But
it is infectious.
Listen to Lori,
it is that.
The more they started to find concern with what she was saying. One of them called it red flags.
Yep, she's
Lori
right.
began saying things like she didn't need to repent, that she was beyond that.
That might be true.
You'll hear from these women that that goes against everything that their religion follows. Everyone must repent.
Yeah, but she might be beyond it anyway.
You'll hear from Serena Sharp that in March of 2019, she attended a girls' weekend with Lori and some other women. They went to the temple, they had lunch, they did volunteer activities, and then Lori asked them to do something a little unusual. She told them that her husband was possessed by an evil spirit.
That's pretty unusual.
And she referred to that as Ned.
Yeah, that'll get my attention.
She told them that Charles was no longer in his body.
Okay.
She asked them to come together and try to cast out this evil spirit.
Where is Charles? If he's not in his body, where's Charles? Does anyone know where he's at?
Serena will tell you that she didn't ask Lori what would happen to Charles if that evil spirit went. She only knew that she had said Charles was already gone.
Okay.
She didn't know if he would come back or his body would just die. Later that month, on March 26th of 2019, Alex Cox texted his sister, Lori Vallow, and said, quote, "Ned is still alive, just confirmed." Lori responded, "It's not Ned. It's a new one."
Ooh.
"Ned is gone. No one has seen him, right? Just talk to him, question mark."
Okay, so we got rid of Ned, but we have a second demon. A second demon has entered the picture. Okay. Does the second demon have a name? Is it also Ned? That would be fun too.
Alex said, "Correct. Charles' body is alive." "What did you learn, question mark?" And Lori responded, "A lot. Still working on it. We'll call you later." As the year went by, Lori and Alex became more determined to get rid of Charles Vallow's body, whatever they wanted to call him. You will hear from Christina Atwood that she attended a gathering on June 9th of 2019. Again with Lori and some close friends, but this time Alex Cox attended. This was the first time she had met him. Christina will tell you that she heard Alex say that he just wanted to kill Charles. In fact, she heard him say this a couple times. And she heard Lori say, in response, that she had been drugging Charles, crushing up JJ's pills and putting them in Charles's protein drinks.
That's bad.
Christina will tell you she was so disturbed by this.
As one would be.
She actually went and confronted Lori the next day and told her that if Charles ended up dead, she would have to go to the police. That's how disturbed she was. Now, Lori, of course, said it was all a joke. What else could she say? But 1 month later, Alex and Lori created that situation to be like Nephi and killed Charles. What about Charles? You're going to learn that Charles and Lori had been together for a long time. They had adopted one of Charles's family members' children, JJ. JJ was everything to Charles. JJ was the reason Charles and Lori were still together. You'll learn that Charles knew about Lori's beliefs, that he was called Nick or Ned or some name. You will learn that Charles told a lot of people about this. And on February 26th of 2019, Charles made a big decision. He had a $1 million life insurance policy, and his wife, Lori Vallow, had been the beneficiary. He changed it. He changed it to his sister, Kay Woodcock. You will learn he did not have to notify Lori about it, and she had no idea. You'll learn that Charles desperately wanted to bring Lori back to the Church of Jesus Christ of Latter-day Saints. You will learn that he was close with Lori's brother, Adam, and he was reaching out to him during this time period. You will hear from Adam. Adam will tell you that he himself had heard the defendant say things that were outside the LDS religion, that she was translated. Charles was possessed. He knew she was no longer following the LDS faith. Then, June 28th, Charles found out that Lori and Chad were having an affair. You will hear that he reached out to Lori about it, Chad's wife, and out to Adam Cox about it. Now, you're going to hear about a lot of these things because the police executed numerous search warrants. You're going to hear that they executed search warrants on cell phone records, cell tower records, and iCloud accounts. You're going to learn that an iCloud account is basically a service through Apple where you can store everything. Photos, emails, documents, whatever you want. This can be intentional, or sometimes it can be unintentional. Your phone or your computer may be saving items there without you even realizing it. You'll learn that for years, Lori Vallow had an iCloud account that was Lori for Style at iCloud.com. But after Charles learned about Chad Daybell on that June 28th, she created a new iCloud account, Lolly Time at iCloud account. Many of these text
New donation from Coughing Bird.
Thank you, Coughing Bird, for the donation. Really appreciate it.
Were recovered from those two iCloud accounts. You're also going to learn about Charles's cell phone. The police eventually recovered it, and they were able to extract the data, look at the messages and things that had been in there. And you're going to learn about those text messages with Adam Cox from July 9th through the 11th. You're going to hear from Adam that they were talking about an intervention, about maybe recording Lori, saying these things and taking those recordings to the stake president. or just confronting the state president about it. They didn't have an exact plan. But on July 9th, Adam agreed to fly to Phoenix to help try to talk to his sister, talk to the state president, get her back into this faith. Ultimately, Adam flew to Phoenix on the 10th, as did Charles. Adam will tell you that he actually, when he got his reservation on the 9th from Charles, reached out to his brother, Alex. He asked to stay with him. And Alex said, sure. You'll see phone records. They had a conversation about it. But when Adam flew into Phoenix on the 10th, remember, that's after that message by Lori that he needed to stay close to her. Adam tried texting his brother. Adam tried calling his brother, and Alex didn't respond. Adam didn't know that his brother Alex had been summoned to help his sister Lori be like Nephi, that it was time to kill Charles. The text messages from Lori to Alex about that intervention that she knew about and being like Nephi show that by the evening of July 9th of 2019, Lori knew that Charles was trying to have an intervention. An intervention. In that text message, remember, she said they are trying to have an intervention. She knew it was Charles and others. She also told her brother he had to stay close for the next couple days because she knew that she was going to be seeing Charles on the 11th when he came over to pick up their son, JJ, to take him to school. She told him, it's all coming to a head this week. I will be like Nephi, I am told.
She said
and
that?
So will you.
That's great.
A few minutes after Lori had texted Alex that message on July 9th that they were going to be like Nephi, Alex called his sister Lori, and they talked for over 56 minutes, planning how they were going to get rid of Charles. Alex would stay close with his gun, and he and Lori would be like Nephi. July 10th of 2019 is a day before Charles was killed. We know from text messages that by 7:18 p.m., Alex was already at Lori's house. He brought a garbage bag with some clothes and an orange duffel bag with his .45 caliber handgun and 2 extra magazines of ammunition. He was prepared. We also know that the evening of July 10th, Charles sent a message to Lori letting her know that he would be over at 7:30 a.m. the next day to pick up JJ, to take him to school. Lori and Alex knew exactly when this murder would happen and where it would happen. They just had to make sure that Charles stayed in the house. You'll hear that on the evening of July 10th, Charles spent his last night alive on a date. He had been on several dating apps and appeared to be moving on. You will hear from his date, Nancy Jo, that she and Charles had met on an LDS dating site a few days before. You will hear that she had talked to him and texted him for hours. Sometimes they would talk for 3 hours on the phone. Nancy Jo will tell you that Charles told her about everything of his relationship, his wife's beliefs, everything that was going on. And he had told her about this change to the beneficiary of his life insurance. She will tell you it sounded like a lot of drama, but she still was interested and wanted to meet this person, and so they met that evening for dinner. She'll tell you that she understood on the 11th that Charles would be picking up his son, that he was actually going to meet a realtor about finding a place to rent here so he could be closer to JJ, and that he was going to try to get in touch with Adam to meet up. And then they were supposed to meet later in the day. She will also tell you that she actually told Charles, kind of joking, but in a way to end the drama, why don't you just tell Lori that you changed the life insurance policy so she knows it's not her? Nancy Jo will tell you the next day, she texted Charles, she called him, and she actually thought he had ghosted her. She didn't know he was dead until a few months later when she saw something on the news, a photo of him, and actually learned that he had been killed on July 11th. So let's talk about July 11th. That morning, Lori Vallow was up early and she was texting with Chad Daybell. You'll learn that we do not have those text messages. They were not saved in the iCloud, but we have them from the phone records. Alex was already at Lori's house with his gun, and everyone knew that Charles was a punctual person and would be there around 7:30 to pick up JJ so he could get to school. You're going to learn that, like many people, Charles had left his GPS data locating service on his phone. So that means when his phone is moving around, it was constantly documenting with GPS the location of the phone. During this trial, you're actually going to see this data mapped out. You'll be able to see Charles come to the house, and then you're going to see his phone leave with the defendant and what she does all day with it. What we know is that Charles arrived at Lori's house at about 7:35. He texted Adam Cox and told him that Alex, or Al, is here. You'll see from photos that Alex's truck was parked in the driveway. Adam responded, "Really, I wonder why he never called me back." Charles didn't respond to that. Adam then texted, "They're planning something." And Charles responded, "Absolutely." Adam told Charles, "I was supposed to spend the night at his house last night. She probably blocked that." Charles told Adam, "What you do is up to you." Adam then told Charles he was going to reach out to Alex and ask him to come get him and see what Alex would do. And in fact, he did text his brother. You'll learn that Charles read that text message from Adam, but he didn't respond. Adam sent one more text message to Charles at 7:49 a.m. on July 11th. He told him that he and his son were going to go play basketball at 8 p.m. to look for a specific church leader who was usually there and have a conversation with him. Charles Vallow never read that message, but you will learn that Lori and Alex did. Charles went to the front door of 5531 South Four Peaks Place, a house that he had rented for his wife, Lori Vallow, a house that he paid for. Charles would have had to knock on the door, alerting Lori and Alex that he was there. He got JJ, put him out in the car, and then Lori Vallow created the reason to keep Charles from just leaving with JJ. Lori Vallow wanted to stop this intervention. Lori Vallow wanted to stop Charles and Adam from trying to take her Temple Recommend away. Lori Vallow, who wanted to be Lori Daybell, and Lori Vallow, who wanted Charles's money. So Lori took Charles's cell phone, and she refused to give it back. Lori Vallow, or Lori Daybell, whatever name you want to call her by, is why Charles didn't just leave with JJ that morning. Lori Vallow is why Alex was able to shoot Charles. Lori Vallow is why Charles is dead. I want to tell you a little bit about the scene, this house, so you can understand what's happening here. When you walk in the front door, there's a big room. It was empty, no furniture. There were mirrors on 2 of the walls, windows on a 3rd wall, and the 4th wall had doorways going into the kitchen and a hallway off to the bedrooms. This is where Charles Vallow was killed. This is where Alex Cox shot him 2 times.
They shot him in the mirror room? All right. I guess we want to be able to view the murder from many different angles.
The first shot to Charles Vallow was to his chest. It exited out his back. Charles Vallow fell to the ground. He put his left hand to this wound, and blood transferred onto it. You will hear from the medical examiner that this shot went through his heart, and that a person can take seconds to up to 2 minutes to die from that type of wound. You will hear that a person can still talk and move after they're shot in the heart. And we know Charles was able to move since he put his dominant left hand on his chest and transferred that blood to his hand. You will see that. As Charles lay on the floor of 5531 South Fort Peaks Place, Alex Cox stood at his feet and fired a second shot. That shot entered his abdomen, and it exited his left shoulder. The angle was significantly upward. Dr. Baumgartner, who is the medical examiner, will tell you that this wound was shored. You will learn that shored means that there was something hard behind that wound. So when the bullet exited it, it caused a different tearing pattern than the other wound that exited Charles's back.
Okay.
It is this shored wound, this exit on Charles's left shoulder, that shows us that there was nothing accidental about this second shot. You will learn from the cell phone that at 7:49, Lori left Charles's house, or left her house with Charles's cell phone, his wallet, his rental car, and JJ and Tylee. She drove to Burger King, Walgreens, dropped JJ off at school before she and her daughter Tylee drove back to the house.
You know, that's the part that I always find interesting when that's like, it's just the nonchalantness after the fact. It's just like, you're just going about your normal routine, like nothing happened. I'm just going to go to Burger King and Walmart and whatever, just like it's a normal day. I always find that really, really interesting. I would think murder might get to somebody, but apparently not.
During this time, while Lori is driving around in Charles's car with his phone, she spoke with her brother Alex twice. The first call was at 7:52 a.m., 3 minutes after she left. The second call was at 8:06 a.m., 17 minutes after she left. You will hear that when Alex and Lori are talking, neither of them had called 911 yet. In fact, you will hear that Alex didn't call 911 until 47 minutes after Lori left. Charles Vallow lay dead on the floor of that house for 47 minutes before he called 911. During this 47 minutes, Alex began...
I'm not really sure it matters very much at that point, to be quite honest. I'm not, once they're dead, I'm not really sure that you called 911 or how long it took you to call 911 really speaks to it. Although I suppose if they had called 911 right away, it might be more like an accident because, oh my God, this person's dead. So maybe it's relevant in that respect, but anything more than instantaneous, I'm not sure if it matters that much, but noted, it was 47 minutes.
And staging the scene and making mistakes. You're going to learn that the police found a bag.
Oh, if they were trying to stage the scene. Okay, I understand. So it's not that they waited 47 minutes, it's what they were doing during the 47 minutes. Okay, tell me more.
A bag that was located on the right side of Charles to the north of his head. Like he had been holding it, and when he was shot and fell, it dropped, it rolled up against one of the walls that had mirrors on it. What you're going to learn that is, Alex forgot that Charles was left-handed. In fact, you're going to learn that Charles was a semi-professional baseball player. He pitched and he batted left-handed. So that bat was on the wrong side. Next, you're going to hear about an injury to Alex himself. Lori had told police that Charles hit Alex in the head with this bat before Alex shot Charles. Classic self-defense. But in all cases, we must look at the physical evidence because it doesn't lie. And the physical evidence doesn't have a bias or a memory loss. Sometimes it's the lack of physical evidence that doesn't lie.
Fair.
So again, we know that this room where Charles was shot had no furniture, mirrors, 2 walls. You learn that although Lori claimed that Charles hit Alex with that bat and then Alex shot him in self-defense, that Alex's gun had no blood transferred on it. Alex was allegedly struck in the head with a bat by a semi-professional baseball player.
That I would think.
Doesn't go unconscious.
Yeah.
And he never touches that injury. Pulls out a gun, is able to shoot this man twice, and then he takes the gun down a hallway and puts it into a room. Never apparently touching his head or this wound. And again, Lori says that Alex was hit with the bat in this room by Charles. But again, what we don't see is any blood on the floor. Charles strikes Alex in the head with a bat. They're grappling on the ground. There's not a single drop of blood on the ground in that room. There's pooling of blood around Charles as he lay there on the ground. There's not a drop of blood going down the hallway to where Alex put the gun. There's not.
That's problematic, right? Oh, the only blood is his blood pooling on the ground where he lay after he was shot. This guy says, "Oh, I was hit in the head with a bat," but there's no blood. There's no trail of blood. There's no blood anywhere else in the house. Yeah, that's the story is not adding up.
Drop of blood in the room where Alex put that gun. There's not a drop of blood on the floor in the kitchen where Alex went to go wash his hands.
Yeah, that sounds unlikely.
There are no towels, sheets, clothing, napkins with blood on them where Alex was holding his head and trying to stop this bleeding from this injury. You will see on body-worn camera Alex Cox, who's on with 911, come out of the house. He will have a phone in one hand and his other hand up, and you will notice that he actually has a pair of sunglasses resting on the top of his head. You will see at some point Alex sits down, and they ask him to move to another location. They talk to him for a while, and then you'll see him eventually touch his head a few times, and then he obtains a napkin or towel, something, and you'll see him at times rubbing his head, patting it. That is the only bloody item you will see. Those sunglasses on Alex's head. He is struck in the head by a baseball player while grappling on the ground. He then pulls out a gun and shoots his brother, puts away this gun, deals with his injury, and yet those sunglasses are still right there on the top of his head. No blood on the floors, no blood on the gun, no damage to the mirrors, that on the wrong side. The lack of physical evidence to help support this self-defense claim.
Yeah, it's not looking real too good there for the defense.
Next, trajectory. The medical examiner will talk to you about the trajectory through Charles's body. The detectives are going to talk to you about the trajectory through the room. Dr. Baumgartner will tell you that the trajectory of that first shot to Charles, the one that went through his chest, through his heart, and out his back, was front to back and slightly downward. It will be less than an inch downward. The detectives will tell you that the bullet from that shot, actually, as it exited Charles's back, ended up across the room in the baseboard. They pulled it out and recovered it. Both of them will say that this shot is consistent with Charles being standing upright with a person in front of him. The gun could be slightly down, or his hand could cause that little bit of downward angle. Dr. Baumgartner will tell you that that second shot that entered Charles's abdomen and exited his left shoulder, that the trajectory of that shot was front to back and significantly upward, 13 inches upward. Dr. Baumgartner is also the one who will tell you about that shored wound. What you will hear from the detectives, though, is that when they found Charles on the ground, off to the side of his left shoulder was the other bullet on the ground, not embedded. They'll also tell you that when they finally moved Charles, they took his body away, they cleaned up the blood on the ground, and they noticed a defect in the flooring, in the wood, consistent with a bullet striking the ground. That defect was located where Charles's left shoulder had been. You will hear that both Dr. Baumgartner and the detectives found the trajectory. The wounds were consistent with Charles laying on the ground, Alex being at his feet when that second shot was fired. The physical evidence does not lie. Charles was on the ground when Alex Cox fired that second shot. The injuries to Charles, the location of the bullet strikes, the trajectory of the injuries both in Charles and in the house all show this was not self-defense. This was a staged murder scene. I told you that Lori Vallow left the house at 7:49 a.m., and we know this because of Charles Vallow's cell phone. The 911 call was placed at 8:36 a.m., 47 minutes later. The police arrived at 5531 South Four Peaks Place at about 8:41 a.m. Lori Vallow and her daughter Tylee returned to the house at 8:48 a.m. When the police first contacted Lori Vallow, they thought she had no idea that her husband was dead, that he'd been shot and killed. Initially, you will see body cam footage of an officer going up and just getting her information. Lori doesn't ask, why are all these police here? Why is there a fire truck here? Why is my brother sitting on the ground over there? Or is he okay? Instead, she comments about her neighbors. You'll learn that the police then pulled her aside to do what they call a death notification, to let her know that her husband was dead. Only to their surprise, she told them she knew she was there. So at this point, the police knew they needed to take her to the police station and question her.
Yep.
You'll learn that Lori Vallow was interviewed by the police. She was treated very kindly. The police asked her what happened. Lori Vallow told the police that she took Charles's cell phone. She admitted that she was the reason that Charles didn't just leave and take JJ to school. She told police in no uncertain terms that Charles was demanding his phone back, and she refused to give it back. She told the police that even as Charles screamed at her for his phone, she walked away from him, wouldn't give it to him.
Okay. Well, you can't do
No
that.
matter what happened or what Charles said or did, she would not give his phone back to him. Lori told police that her daughter, Tylee, came out of the room during this screaming with a bat. That Charles took it away from Tylee, and Tylee fell on the ground. And she told Tylee to go out to the car with JJ. She still didn't return the phone. She told police that Alex came out, that he and Charles got into this scuffle with the bat, that Charles hit him in the head with the bat. She still didn't give Charles back the phone. What she did instead was take his phone and go around that wall into the kitchen. Left the situation. Time to let brother Alex be Nephi. While she's in the kitchen, she said she heard the gunshot, came out, saw Charles on the ground, and her brother standing at Charles's feet. Then she told the police she left. You'll learn that the police actually had no idea that Lori still had Charles's phone. Even when they're interviewing her, she still had it. Police are processing the house, looking for it. Where is it? I can't find it. Later in the afternoon, you'll hear that the police actually called Lori and Alex and asked them to come back to the scene. And when Lori arrived, they told her they couldn't find Charles's phone. And she told the detective that she found the phone in the car. Found it in the car. She gave Charles's phone to Detective Enclan and then provided her with Charles's PIN number to get into the phone. You'll learn that after those interviews in the morning, Lori and Alex went back to Alex's house in Santan. And there they went through Charles's phone. You'll learn that Alex actually took photos of some of the messages between Charles and Adam, including Adam's flight reservations. And he later sent those to his sister, Lori. July 11th. Lori didn't tell any of Charles's family he was dead. She didn't tell Adam that Charles was dead. She certainly knows they'd been talking. The next day, Lori texted Charles's sons from his prior marriage and told them, "Your dad is dead." Charles's sons reached out to their Aunt Kay about this, and you'll learn that Kay and her husband had to Google this, see if it was true. They found out that Charles had been shot. So what about the money? That life insurance policy. Charles Vallow had $1 million life insurance policy. When he got it, his wife, Lori Vallow, was the beneficiary. We know that Charles died on a Thursday, July 11th. That next Monday, July 15th, Lori Vallow called Banner Life Insurance. The call was recorded, and you'll hear it. She told the agent that Charles had been accidentally shot. It was an accident. And that she was the beneficiary.
Bad news, Lori.
Both of those statements are not correct. There was nothing accidental about that shooting, and she was not the beneficiary. 3 days later, on July 18th, Lori Vallow learned that she was not the beneficiary. Banner Life Insurance could not and would not tell her who Charles had changed it to.
Yeah.
But Lori was angry about it.
I bet she was. I bet she was. She doesn't get her $1 million payday. Life is sad for her. Very, very sad. Wah, wah, wah.
And you're going to learn that on July 18th of 2019, there's another very important text message in this case. The first one on July 9th between Lori and Alex when they discussed being like Nephi. And on July 18th, 7 days after Lori and Alex killed Charles and Lori learned she is not getting $1 million life insurance policy, she sends a message to Chad Daybell.
Oh, this should be good.
Quote, "So I talked to the insurance company. He changed it in March. So it was probably Ned before we got rid of him. You can't tell me who, of course, but it's done. I'll still get $4,000 a month from SS." In this text message, Lori tells Chad that it was probably Ned, that evil spirit inhabiting Charles's body, that changed the life insurance policy before they got rid of him, before they killed him.
Well, I suppose if you can prove that, then you can void the change of beneficiary. So good luck with that. You could go to court and be like, no, it wasn't really my husband who changed. It was really his demonic possessed person, Ned. That could be a fun case for somebody.
After Lori found out that she was not the beneficiary, she was so angry that she actually went through Charles's laptop, found the beneficiary change form, sent photos of that to Chad, and she also confronted Kay about it. The $1 million she had expected to get was gone. But as Lori told Chad on the 18th, she was still going to get money from the death of Charles. Lori knew already that a month before going to see Social Security, how much money she would get for JJ and for herself as a caregiver as a result of Charles being killed. $4,000 a month. Ladies and gentlemen, the evidence in this case is going to show you that Lori Vallow, Daybell, conspired with her brother Alex Cox to kill her husband, Charles Vallow. When Charles let Lori know he was coming into town, she quickly got the pieces into place. Alex came to her house with a gun. Lori created the way to keep Charles inside the house so that Alex and she could be like Nephi. To kill Charles Vallow to better at least her life so she could be with Chad and she could live off that life insurance policy. As we go through this trial, you will see photos of Charles's injury, photos of the crime scene, and hear testimony that will prove that this was not self-defense. As we go through this trial, you'll be provided with phone calls, emails, text messages, and hear testimony that lays out the motive for this murder, money, and Chad Daybell. You will see text messages and hear from people who Lori trusted and who were later pushed away, people who really don't want to be part of this trial, but were pulled into it by this defendant and her desire to get rid of Charles to be with Chad. People who heard Lori for months saying Charles was gone, possessed. People who will establish that this murder was premeditated. You will hear text messages from July 9th by Lori to her brother, Alex Cox, that he had to stay near her, that it was all coming to a head, and she would be like Nephi, and so would he. A justified killing, just like the prophet. And later, the text message to Chad where she told him that Charles changed the life insurance policy before they got rid of Ned. A confession by Lori of how religion and money were twisted to justify Charles's murder. At the end of this trial, the state will come to you and ask you to hold the defendant responsible for the death of Charles Vallow and find her guilty of conspiracy to commit first-degree murder. Thank you.
Okay, I mean, that's pretty solid. That's just a standard, solid, a little paint by numbers, but good job. And I have to give her bonus points because this case with the players involved, especially once you get into what happened in Idaho, which we're not really dealing with now, but this is the most, I need to break out the cork board and the string and the pins in the 3x5 cards just trying to figure out the story. It's one of the most jumbled nightmare stories of law we've ever seen. So I have to give her points just for being able to put together a cohesive narrative. Perhaps slightly fact heavy, but good job. She did fine. Okay, so let's find where Lori Vallow picks up her opening. And see what Lori Vallow has to say in her own defense. This should be good.
Ladies and gentlemen of the jury, I have been charged with a crime, a serious crime. And the only question here is, did I commit this crime? Conspiracy. Conspiracy is an agreement between two or more people to commit a crime. Just want to move this closer. Okay, so you see? Okay. There has to be an agreement. There has to be a plan. The evidence in this case will show that Charles Vallow and I got married in February 2006. It will show that it was my fourth marriage and Charles' third marriage.
Maybe you're just not very good at the marriage. You know? Yeah. Also, you found 5 men to marry you? All right.
At that time, we each had 2 children. I had Colby, who was 9, and Tylee, who was 3. Charles had Cole, who was also 9, and Zach, who was 7. The evidence will show that our family moved from Austin, Texas to Chandler, Arizona in 2009. The evidence will show that Charles and I adopted our great-nephew, JJ, who was born in 2012.
Okay.
It will also show that Charles and I were married for over 13 years and were raising 5 children. The evidence will show that I was a licensed cosmetologist and worked as a hairstylist for 20 years while we lived in Austin, Texas.
Okay.
The evidence will show that Charles was a licensed life insurance salesman and worked as an independent contractor, selling life insurance policies and annuities, and owned his own business. The evidence will show that Charles and I purchased life insurance policies early in our marriage, and Charles had them issued to the maximum amount possible to each of us. The evidence will show that Charles was 17 years older than me, and that because of Charles' age and an issue that he had with high blood pressure, the maximum amount of life insurance that could be approved for Charles was $1 million.
I'm not necessarily sure he took out the maximum policy necessarily goes in your favor when the state's theory is you did it for the money. Yeah, and it was the most amount of money possible.
Maximum amount of life insurance that I could be approved for because of my age and my health was $2 million. The evidence will show that throughout our 13-year marriage that we always had life insurance policies. When a 10-year policy lapsed, Charles would shop for another company who would approve us for the maximum amount of life insurance. The evidence will show that this was Charles' job. This is what he did.
Right.
I helped him in this business, and this is what he did. The evidence will show that in 2016, Charles repurchased a new $2 million life insurance policy on me, and he was the sole beneficiary. The evidence will show that Charles and I had a happy marriage for 13 years. That he was, in fact, a baseball player, and that he played high school, college ball, and AAA ball.
Okay.
And that he was, in fact, a left-handed pitcher, a southpaw, they call him. But he was a right-handed batter, as could be attested to by anybody who knew Charles well and his high school baseball coach, Greg Davis. The evidence will show that Tylee was, and in 2014, our family moved from Chandler, Arizona to Kauai, Hawaii. We lived there for 3.5 years and returned to Chandler in 2017. The evidence will show that Tylee was 3 years old when Charles and I got married, and that when she became a teenager, the relationship between Tylee and her stepfather, Charles, became so difficult that Tylee and Charles had to seek a therapist, a family therapist, to stop them from fighting. The evidence will show that together, Charles and Tylee met with this therapist after we moved back to the mainland in 2017. The evidence will show that in April of 2018, Tylee's biological father passed away from a heart attack. And at that time, Charles called Social Security and made an appointment at the Social Security office.
I'm going to object to hearsay.
Sustain.
It will show that we did get Social Security for Tylee for her deceased father until she was 18 years old, and she was 15 years old at the time. The evidence will show that Charles and Tylee's fighting increased greatly in January of 2019 when Charles and I temporarily separated. The evidence will show that several people witnessed these terrible arguments between Tylee and Charles that increased to physical in 2019. Charles and Tylee had major increasing arguments, two in February of 2019, one of March in 2019, which was captured on video, one in May of 2019, one in June of 2019, and then the worst of all in July 2019.
Okay. I mean, that's a pretty reasonable actually idea of defense, that this guy is violent and he's having a lot of violent interactions, and this is just another violent interaction, and therefore it's more likely to be self-defense. Okay. I mean, that's an idea. All right. It's something. All right. Carry on, you demon woman.
The evidence will show that in March of 2019, Charles pulled JJ out of his special school and moved him to Houston, Texas, while we were temporarily separated. Tylee and I then joined Charles and JJ in Texas in April 2019 to reconcile. The evidence will show that JJ was diagnosed with severe autism when he was 3 years old while we lived in Hawaii. The evidence will show that for 2 years, JJ was attending a school in Gilbert, Arizona, a special school for children with autism. It's called Lauren's Life Academy. The evidence will show that in June of 2019, in JJ's best interest, Tylee, JJ, and I moved back to Chandler, Arizona to re-enroll JJ back in Lauren's Life Academy since he had a difficult time with the Houston, Texas schools with no services for his autism. The evidence will show that Charles and I agreed it was in JJ's best interest to be in school where more services were available to him, so Charles and I rented a house here in Chandler. On the day in question, July 11th, 2019, Charles and I were renting two houses, one in Houston, Texas, where he mainly resided, and one in Chandler, Arizona, where I resided with our two minor children, Tylee and JJ. By this time, our three older boys, Colby, Cole, and Zach, were adults and not living at home any longer. The evidence will show that during the months of June and July, that my husband, Charles Vallow, began to send me threatening text messages.
Okay.
These messages were seen by my sister Summer, and that worried her. The evidence will show that Charles insisted on flying into Phoenix on July 10th, as we've heard from the state. The evidence will show that I advised Charles that he could not stay with us at the Chandler house because he could not get along with Tylee, and I did not want them to get into another fight like they had 3 weeks prior.
Okay.
The evidence will show that it was ultimately decided between Charles and I on text messages that he would stay in a hotel because he traveled for business all the time and stayed in hotels all the time, and that I would book it for him since I worked for him and booked all of his travel. The evidence will show
What is that beep beep? Is that me or is that the broadcast?
For him since I worked for him and booked all of his travel.
I think it's in the broadcast. I'm not sure what that beep beep is, but it's in the video. All right, never mind.
The evidence will show that Charles did in fact fly into Phoenix on Wednesday, July 10th, and stayed in the hotel that I booked for him. The evidence will show that Charles paid to fly my brother Adam Cox into Phoenix from Kansas on the same day, Wednesday, July 10th, 2019. The evidence will show that Charles planned to come to our Chandler home and pick up JJ and drive him to school on Thursday morning, July 11th, 2019. The evidence will also show you that Lauren's Life Academy opens its gates at 8:25 a.m. in the morning.
You know, I have to give her points. I have to give her credit, although my expectations were pretty low. But she's telling a narrative, and she's telling it from evidence that will show, and she's presenting the evidence in a legally correct way. And she has a theory that she believes can at least be backed up by some evidence that would tend to suggest that this might have been self-defense. So, you know, points points, you have an idea that could theoretically work. Of course, it depends what the evidence will show, but in principle, maybe. It's an idea. It's more than I expected. You go, demon woman.
And the evidence will show that Charles showed up at our Chandler residence around 7:30 in the rental car I booked for him on the morning of Thursday, July 11th, 2019. The evidence will show that Charles began texting with my brother, Adam Cox, before he entered our residence. And that Charles and Adam were discussing in their text communications that my other brother, Alex Cox, was at the residence. The evidence will show that on the morning of July 11th, that Tylee was asleep in her room and my brother Alex was asleep in the guest room. The evidence will show that when Charles entered the house, only JJ and I were awake and present. The evidence will show that after we put JJ in the rental car, that Charles came back into the residence to receive his phone, leaving JJ in the front seat of the rental car with the engine running. He was 7 years old. The evidence will show that Charles began to scream at me when I refused to hand him his phone. The evidence will show that Charles' screaming woke up Tylee and Alex. The evidence will show that Tylee came out of her room with a bat to protect me, her mother, from her stepfather, Charles Vallow. The evidence will show that Tylee and Charles fought over the bat, and that after a struggle over the bat, Tylee fell onto the ground. And Charles lifted up the bat to hit Tylee with the bat.
Okay.
The evidence will show that Alex then intervened to protect Tylee from being hit with the bat. He did not have a gun. He was not wearing a shirt. He was pulling up his jeans because he just woke up and came into the room where he heard the screaming. The evidence will show that Alex and Charles got into a physical struggle for the bat and fell onto the ground. The evidence will show that Tylee, who was on the ground, was lifted up by me and sent outside to get away from the struggle and to protect JJ, who was still in the running car, in the rental car in the driveway. The evidence will show that after this struggle on the ground between Charles and Alex, that Charles prevailed with the bat and began to come towards me with the bat as I ran away from him into the kitchen. The evidence will show that at some point while I was running away from Charles, who was chasing me with the bat, that Alex apparently retrieved his gun. The evidence will show that I ran outside to the children and that Alex shot Charles in self-defense.
Okay.
The evidence will show that Tylee and I had both run outside without shoes. The evidence will show that JJ was still in the front seat of the rental car with the engine running and struggling to get out of the car. Tylee was trying to keep him in.
I mean, if she can actually show any of those things, that, then, good for her, I suppose. If she can actually show all those things. I don't know.
The evidence will show that Tylee and I got into the rental car with JJ and drove away. The evidence will show you that I drove the children away from the residence towards JJ's school.
Although it's still a little unclear, like why, if this is true, why didn't someone call 911? With more immediacy is a little unclear. But okay. The guy in North Charleston who set Tesla stations on fire was just indicted by the grand jury on arson. Awesome. Go get him. Thanks, Swamp Bear.
Can I grab a tissue?
Yes.
Maybe if she gets off, she can be a partner in my law firm. The Mueller Vallow law firm, defending you no matter what. I'll sponsor her for the bar. It'll be great.
The evidence will show that I drove the children through the Burger King drive-thru that Charles had promised JJ.
I guess you got to get that Burger King no matter what happens. There was a promise of Burger King, damn it. And despite murder, we're getting our Burger King, baby. I mean, that is follow-through dedication. Wow.
The evidence will show that we continued to drive towards JJ's school and that the gate was not yet open at JJ's school. So we drove a block west of the school to a Walgreens where I ran in to purchase flip-flops for Tylee and myself so that we could walk JJ into school on the hot pavement. The evidence will show that Tylee and I...
When you went to Burger King, did you get it your way?
returned directly to our residence where we met with police in our driveway. The evidence will show that we were spoken to by the Chandler police officers. And the evidence will show that Tylee and I were told by the Chandler police detectives that Charles had passed away. The evidence will show that we were put into a police van and driven to the Chandler Police Department. The evidence will show that Alex was taken by police in a police car to the Chandler Police Department, and that we were all three separated into interrogation rooms and we were each interviewed.
That's pretty typical.
The evidence will show that next, Tylee and I were brought back together into a room at the Chandler Police Department and were introduced to a victim's advocate who was very kind to us. Mm-hmm. The evidence will show that after speaking to the victim's advocate, that Tylee, Alex, and myself were put back into the police van and driven back to our residence. We were directed by the Chandler detectives to take the rental car and return later to the residence after we picked up JJ from school. The evidence will show that we did as instructed by the Chandler detectives. The evidence will show that we drove to Alex's residence where we attended to the wound on the back of his head. The evidence will show that Alex was then contacted by the Chandler detectives to return to the residence so that Alex could walk them through the events that occurred with the detectives at the residence. The evidence will show that Alex, Tylee, and I did return to the residence as instructed. And the evidence will show that Alex entered into the residence with Detective Moffett, but that Tylee and I were met by Detective Inkland in the front yard. The evidence will show that at the time, Detective Inkland asked Tylee and myself if we had Charles' cell phone. Tylee retrieved Charles' cell phone from the rental car and gave it to Detective Inkland at 3:11 p.m. on July 11th, 2019. And at that time, Charles' phone was placed in the custody of Chandler police detectives. The evidence will show that Detective Inkland asked us if we knew the passcode on Charles' phone, which Tylee proceeded to give to Detective Inkland. The evidence will show that Tylee and I left the residence to pick up JJ from school, while Alex remained at the residence with the detectives. The evidence will show that by the time Tylee, JJ, and I returned to the residence, that all police, EMS, CSI, and detectives were gone from the residence and only Alex remained. The evidence will show that the next day, I contacted Chandler Police to inform them that Charles' belongings were still at the hotel. I asked the detective if I should go get them, and I was told that they would take care of it. The evidence will show that I asked the detectives, what should we do next? And they directed us that they would contact us in about 3 weeks after their supervisor passed off their reports and Alex could go to the police station and retrieve his gun. The evidence will show that the last thing I heard from Chandler Police Department until June of 2021, 2 years later, when I received a grand jury indictment from them for this alleged crime. The evidence will show that Chandler police treated this incident as self-defense.
And object to that.
Objection sustained. The jury should disregard that last statement.
The evidence will show you that my brother, Alex Cox, passed away on December 12th, 2019, almost exactly 5 months to the day after Charles, my husband, passed away.
Who cares?
The evidence will show that Alex passed away from a blood clot in his lung.
Objection. Again.
I'll sustain the objection. It's not relevant for this matter.
The evidence will show you that I am the only person being charged with this crime.
I would object to the relevance of that.
Sustained.
As the state has mentioned, they're alleging that insurance money was my motive. Social Security was my motive. Spouses having insurance policies is not a crime. Collecting Social Security is not a crime. Self-defense is not a crime. A family tragedy is not a crime.
Fair enough.
It's a tragedy.
Well, I suppose a family tragedy is a tautologically true statement. So you got that going for you. Well, that was exciting and fun. So I guess that brings us to the end of the opening arguments. Yeah, if she can actually show any of those things, then, you know, maybe there's an idea in there somewhere that could work. Don't necessarily have high hopes for her, but, you know, okay, maybe there's an idea in there that she could possibly sell if she's really, really good at it. So, you know, but of course the problem is her ability to present evidence, her ability to ask questions, including on cross. And I've heard tell that her cross-examination skills are not necessarily great, including from yesterday. So apparently there was some cross-examination yesterday and it didn't necessarily go well. So maybe we can find that. She didn't give a good close. It's not time for close. Those were opening statements. You mean the end of her opening wasn't great? Yeah, it was fine. It was better than my expectation. Let's see if we can find. All right, so this is from yesterday. Now, where in yesterday do I have to go for the really exciting cross-examination? That's the real question. Is it just at the beginning of the day or is it somewhere else? Does anyone happen to know? The end of the opening wasn't there? Yeah, fair enough. It wasn't fantastic. It was just better than my expectations.
Detective Coons, I know we didn't really establish yesterday. I know that you're retired. Is that okay if I call you Detective Coons, or would you prefer something else?
Detective is fine.
Okay, thank you. Detective Coons, yesterday you testified that no stippling was found as a result of the shot on my husband's chest. Is that correct?
To my knowledge, none was found.
Okay. So would it surprise you if the medical examiner expressed in his defense interview that there was stippling found in that shot?
Would it surprise me that he had found it? Not necessarily based on the information.
Okay. Would it surprise you if the medical examiner expressed that the shooter would have had to be 2 to 4 feet away for that stippling to be present?
And this is from your interview or from the report?
From the interview.
Okay. No, that actually would still be consistent with my observations at the scene.
Okay, great. If someone very muscular like my husband were 2 to 4 feet away from you holding up a bat, would you consider that a threat?
And I would object to speculation, relevance.
Your Honor, I'm asking for his opinion as a professional and as a firearms expert.
He's not, okay.
That goes to the ultimate
hold on.
decision.
The objection is sustained and it calls for a legal conclusion.
It calls for a legal conclusion?
Yes, move on.
Were you present, Detective, when my husband was shot?
No, ma'am.
Is there a video recording of it?
To my knowledge, no.
So is your opinion then an educated guess about what really happened?
It's based on known facts.
Okay. Were you aware, Detective, that my husband and my brother were very good friends?
No, ma'am, I didn't know the relationship.
Did you know that they hung out and played golf together?
Objection, relevance.
Sustained.
Your Honor, I'm going somewhere with this.
Oh,
My
guess
follow-up question will explain.
I guess you can answer if you knew that they played golf.
I did not know.
In all of your investigation of my life, you never came across this information?
Objection, relevance.
Sustained.
Are you familiar with my husband's wishes for his funeral?
Objection, relevance.
Sustained.
Did you learn in your investigation that he named my brother Alex as one of his 5 best friends?
And I'm going to object again to relevance.
Sustained.
Did you read the reports in this case?
I did not read all of the reports in this case. No, I've read mine and I've authored mine, but I have not read the other reports.
Fair?
None of the other reports except for your own?
That's correct.
Okay. Detective, are you familiar with the follow-up report you wrote dated July 29th, 2019?
You're going to have to be a little bit more specific.
Did you review your reports in preparation for your testimony here today?
Yes, but I have not memorized the dates of when I made a report entry.
Okay. Would you like to see it to refresh your recollection?
That would be helpful.
Okay.
Thank you.
She could be doing worse.
Thank you.
I guess she watched a couple episodes of Law and Order or something, man.
Okay.
Does that look like a true and correct copy of your report, Detective?
I believe it is.
And those Bates pages run from what to what, please?
They're obscured in the footnotes of it, but it looks like it's 126 through 131.
Okay. And on the last page of your report, on Bates page 131, you explain what a shored wound is.
Yes, ma'am.
Could you read that underlined portion?
I'm going to object to hearsay to reading it.
Sustained. You can ask him to explain what a shored wound is.
Okay. Can you explain to us what the shored wound is that you explained in your report?
Yes, a shored wound would be a wound created as an exit wound where the projectile is exiting the body and the body is either up against a firm surface or firm material like spandex type thing. That's how it's been explained.
Like spandex? Is that what he said? Did he say a firm material like spandex? That's what I heard.
To me.
Okay. That's fair. You said held in place by tight clothing. Is that correct?
Yes.
Okay.
Really? Did he really mean spandex?
Did you,
Seriously?
in fact, and it says in your report, did you in fact collect my husband's clothing?
Yes.
How much? I mean, I'm not an expert on this issue, but I'm genuinely surprised. You're telling me the bullet wound and exiting a body will be markedly different if the person is wearing spandex clothing? That is surprising news to me. I'm amazed.
Okay. And you took the clothing, it says, to the property storage facility. Is that correct?
Yes, it went to a drying cage.
Okay. Detective, are you familiar with bamboo clothing?
I can't say that I am.
Okay. Were you aware that on July 29th, 2019, my husband was wearing a $200 bamboo workout shirt?
Objection, relevance.
No, it's relevant.
He can answer if he knows.
I have no idea what the cost is.
Are you aware that bamboo is a heavy-duty fabric, not to rip or tear except under extreme conditions?
I've not done any research into bamboo fabric.
Okay. So could this fabric of his shirt have caused the wound to be short?
It could have been a contributor, but it would not have been in this particular case.
Why so?
The body would have been on the floor where the bullet defect was in the floor.
So you just said in your report earlier that a short wound could be caused by tight clothing. Is that correct?
Correct.
And you're saying that could not have happened in this case?
The shirt did not appear to be tight clothing to me.
You
Well,
can
it
tell
was
the
made of
difference?
bamboo, as we established.
I mean, can you tell the difference from that? That would be my follow-up question. It's like, or I don't know, but it'd be my interest as a lawyer. It's like, can you tell the difference? Maybe you can. Would a shored wound as a result of clothing be markedly different than a shored wound because of a hard floor? Maybe the answer is yes, but I'd be curious. I don't know.
Right? Is that correct?
I am taking your word for it. I do not know that it's a bamboo shirt.
Okay. And you did not investigate that at all?
No.
Yeah, his point to the floor is more dispositive. Well, I don't think actually that's necessary. Yeah, I think that's a bit of it's slightly conjectural because the bullet wound on the floor may not necessarily be related to the bullet wound that caused the death. I don't know how many shots were fired. Was it just one? If it was just one, then yeah, probably not so much. It was probably the floor. So if it was just one shot, then, and there's only one bullet wound mark on the floor, then okay, that's a bit more speculative. Okay, I agree. All right, never mind. I retract my prior statement. I retract my prior confusion.
But you had the shirt in your possession,
It was seized as evidence, yes.
and you never checked what kind of fabric it was,
No, ma'am.
and you never checked if that could be a possibility,
No, ma'am.
and you knew that spandex was kind of a material that could make that kind of short mark that you just mentioned.
If it was two shots, one when he's standing and one on the ground, then then it's a bit more of assumptive. It's because you're assuming that the shored wound is the same as the wound on the floor, as opposed to the one from the bamboo shirt, is her point. I'm not sure how it really matters legally, but I guess it matters in terms of where they're standing, might be indicative of self-defense or something else as opposed to being helpless. So I guess it does matter legally. So yeah, there might be a point in here that she's trying to get to. Okay. They found the other bullet in the baseboard. Yeah. But you're still like, which... You still don't know necessarily where he was necessarily from that. Because you found the bullet in the baseboard does not tell you necessarily where any of them were standing or sitting or, at the time of the shot. It's not dispositive. I'm just trying to think about possible scenarios. I'm just trying to think of ways the bullet could wind up in the baseboard without it necessarily being the shot that's causing the wound, Maybe I'm thinking about it too hard. I'm just trying to give her some daylight. I don't know.
Incorrect?
It would have to be super tight clothing.
Super tight clothing?
Yes.
Or a fabric that's even stronger than the spandex that you mentioned?
The strength of the fabric, I don't believe, has a huge play in it unless it is form-fitting and compressing the skin, much like a hard surface or firm surface would.
Okay. But what you said in your report was that held in place by tight clothing could cause a short wound.
If it's tight
That has been
clothing.
explained to me, yes.
Okay.
Okay. So it has to be tight clothing. The strength of the material isn't necessarily the thing. It's the compression of the skin that's the thing. Yeah, so it has to be tight clothing, not necessarily firm clothing. Cool.
Detective, in your report, you mention So it is possible that his shirt could have caused the wound and not the fall.
I'm going to object to asked and answered.
I'll let him answer.
I don't know if it's possible or not for that particular shirt to have caused a short wound.
Because you did not do any investigation about the shirt.
Because the shirt did not appear to be form-fitting and very tight.
Move on.
Did it cover over the shoulder where the wound was?
It was a full T-shirt at the time.
That's what I'm saying. So was the T-shirt, where the wound was on his back, where the bullet exited, was his shirt covering that part of his body?
Certainly.
Okay. Was there a hole in the shirt at that location?
Yes, ma'am.
How big was the hole?
The size of the bullet?
So small.
Yeah.
Small.
Fabric stretches and contracts, so it was a bullet size.
Okay. So when you had this shirt and you saw the bullet hole, it was after the shirt had been cut off by the firefighters, is that correct?
It hadn't been cut off, it had been cut down the middle, down the front,
So just the front was cut, so the back was intact?
minus the defects that we have seen from the bullet and exits, yes.
Okay. So you were able to measure that. Do you have a measurement for those bullet holes in the shirt?
No, ma'am.
Okay.
She's doing surprisingly good. I have to give the woman credit. She's doing surprisingly good. I'm suitably impressed. I've seen worse attorneys than this. Maybe she's the smartest one in the room after all. Who knows?
So it is possible that his shirt could have caused the wound, the shored wound.
Object again that we've asked and answered this 3 times
Sustained.
now.
Okay, so is it possible that any shirt could have caused a shored wound in any kind of,
And I'm going to object to foundation as to any overly broad.
as an expert,
Let me rule on the objection.
okay, I'm sorry.
All right. I'll sustain the objection.
As an expert and in your professional opinion, could that fabric of his shirt that he was wearing that day caused a shored
You didn't want to ask that question. That was the wrong question. But we can give her a break because she doesn't know any better. But that was the wrong question.
wound?
Again, I'm going to object to asked and answered multiple times.
Sustained.
In the last paragraph of your report, Detective, you indicate that you were able to confirm your suspicion of the body position at the scene. Is that correct?
Yes, ma'am.
And what did you mean by suspicion?
Well, at the time, I couldn't see through his body to see the full trajectories, so I did need the information from the autopsy. The trajectory rods helped with that, as well as the doctor's statements. All of that combined did give me the 2 different bullet paths.
Okay. And then, can you tell me, Detective, what happened to my husband's shirt? Do you know where it is now?
It is in evidence, as far as I'm aware.
And it's, when you looked at it, where was it?
The last I physically saw that shirt was when I handed it off to a crime scene tech to put into a drying cage with the instructions, once it was dry, to have it moved into the property facility.
And so, did you see it after it was in the property facility?
No, ma'am, I have not.
So you saw it before it was dried, is that correct?
While it was wet from the medical examiner's office, yes.
And that's when you examined it?
I had seen it at the scene as well.
And then, did you ever examine it?
No, ma'am.
Okay, so you saw it twice.
That's fair.
Okay.
Not bad.
So you didn't test it for anything?
I did not.
Did anyone test it for anything?
I
that
do
you're
not
aware
know.
of? That you're aware of?
I do not know.
So you're not aware of it?
Correct. I do not know if anybody else tested it.
Okay. Was the wood,
I mean, she's pretty solid, man. I'd hire her as an attorney. She's doing pretty good.
Wood floor tested for any fragments of the projectile?
It was actually seized, so it was not tested.
And what does seized mean?
We cut it out of the floor and kept it.
Right, and then was it tested after it was seized?
No, ma'am.
So the wood floor plank that was taken from my residence was never tested for any fragments of the projectile?
The projectile was intact, minus a deformity to it.
Okay. But there wasn't any reason, are you saying there was no reason to test it?
There had been no implication or indication that there was a request for it to be tested.
And you wouldn't do that to see if the projectile actually hit the floor?
No, ma'am. All the other circumstances and information that led up to that decision to seize the floor, everything appeared that it was going to be related to the actual bullet that passed through your husband's body and struck the floor.
Wouldn't testing the floor actually be the easiest way to be sure that the bullet hit the floor?
Not necessarily would it leave anything behind. Like I said, the bullet was a full metal jacket. It was still intact. There had been a significant amount of blood that had pooled in it. I do not know if there would be residue left behind in it for testing.
Fair. Okay. Was the projectile tested for any marks from the floor?
No, ma'am.
Were you aware that this was a rental house that we lived in?
I believe I'd heard that.
Okay. Were you aware that we had only lived there for about 3 weeks prior to this incident?
I knew it was a short time period, but I did not know the actual duration.
Did you know that? You know that by the time you wrote this report, right?
I don't recall knowing the exact time frame that you had lived there.
Okay. So the defect in the floor of the rental house that we lived in could have already been there before this incident. Is that correct?
Not in my opinion, no.
But it could have.
An objection, Your Honor, asked and answered.
Sustained.
So of all the divots that we saw yesterday in the pictures on the floor, it could not have been there beforehand?
Again, asked and answered.
I'll let him answer. Go ahead.
The divots I believe you're referring to were extremely smaller than the actual defect, which was still relatively fresh and not sealed like the other divots were.
Okay, can we see? These were previously published, so I can use them, right?
Yeah.
Can we look
Just
at these?
refer to the exhibit number, please.
Okay. Just put it on. Detective, can you see that? I can't see that very well. I'm there. So, in Exhibit 57, Detective,
I'm looking.
this, where my pin is pointing,
Yes, ma'am?
that's the defect that you're referring to where the bullet struck. Is that correct?
Yes, ma'am.
Okay. And these defects were already previously at the residence. Is that correct?
Yes, ma'am.
And do they look that much significantly different than that to you?
Yes, they do.
I'll take your word for it. They kind of look similar to me, but okay.
What do you think the measurement difference in that is, in your professional opinion?
There is no scale in this photograph. It would be difficult for me to give you an estimate.
So in your estimation, this defect is much larger than this defect. Is that correct?
The second defect you're pointing to appears to be wood grain indentations. The other is an actual defect in the board.
Okay.
I'm not sure I can tell that from that photograph, but maybe he knows from other things, but I can't tell the difference between them. But maybe I'm just not an expert on all things wood. Where's law and lumber when you need them? Maybe Rob can help us and tell us if there's a significant difference. Rob, where are you?
Thank you. But this defect, this piece of wood that was cut out, was not tested. Is that correct?
Again, asked and answered.
Technically correct, but I'll let him answer.
Correct. To my knowledge, it was not tested.
Thank you. So do you know, Detective, for a fact, that the defect on my wood floor was caused by the second bullet?
And again, I'm going to object to asked and answered.
Sustained.
When we looked at the projectiles yesterday, the one from the baseboard clearly had white paint on it from the baseboard. Is that correct?
Baseboard or the drywall, perhaps.
Okay, but we all saw the white paint. Is that correct?
There was a white marking on it.
Was that tested for the white paint?
No, ma'am.
Why not?
There was no decision made to have it tested.
Because it was logical that it was in the baseboard where the baseboard was painted white, right?
It was very clear that it had passed through your husband and lodged in the baseboard, and upon recovery, there was no deformation to it, indicating that it was a straight-on impact or relatively close, so that it embedded itself into the baseboard.
Correct. So it wasn't tested because it really didn't need to be, in your opinion?
Correct.
Okay, that's fair. Next, we looked at the projectile that, according to you, made the defect in my wood floor. Is that correct?
I don't understand your question. Next, we look at it, but I don't see anything.
Oh, we saw the projectile. Can I find out what exhibit that was?
Your paralegal has all those photographs.
Can we use the actual exhibit?
She can approach and.
Okay.
and Are you looking for the actual projectile?
Yes.
Are we trying to find the bullet? The actual bullet? Look at this bullet.
I believe it's a smaller. Do you want her to hand that to the witness?
Is Laurie Vallow not given permission to approach the witness? She doesn't have permission to approach. Aww.
Is that 239? Okay. Detective, for the record, you're looking at Exhibit 239, is that correct?
Yes, ma'am.
And is that the projectile that we are talking about that you claimed made the divot in my wood floor?
Yes, ma'am.
Okay. So was that projectile was not tested, is that correct?
Your Honor,
Is that what you
I'm going
said?
to object to asked and answered at least 3 times.
Sustained.
Does that projectile look pristine to you?
No, ma'am, as I've previously testified, it is slightly deformed.
What side is it deformed on? What part about it is deformed?
The back end, the heel area is compressed a little bit so that it's now oval as opposed to circular.
And that would indicate what?
That would indicate that as the bullet struck something firm on its side, it compressed, and then it continued on moving.
Okay. So that's what you mean by a shored wound. It hit up against something, is that correct?
The terminology as it's been described to me is it's the skin is against a firm surface. So in this particular case, the floor would be the firm surface. So as it's entering or exiting your husband and starting to try to enter the floor is forcing the bullet to kind of ricochet, but the body's still keeping it in place. So it's now deforming a little bit, and it's still expending its energy to escape from underneath the body.
Okay. And if my husband was in fact laying on the floor, how did it get out from under his body? Wouldn't it have gotten stuck under? That's my question.
Just what?
Could you explain that to me?
I think I just did. So the bullet is a full metal jacket. It still has its energy. Until it starts striking things to cause resistance to it, to slow it down, it's going to expend its energy at a normal rate. I think I just lost the mic, I'm not sure.
No, it's on.
Okay. When it starts striking firm objects, then it'll start bleeding the energy away. And in this particular case, as it's exiting your husband's body, it's impacting bone, it's impacting the flesh that's compressed against the floor, and it's impacting the floor now. So there is going to be a lot of resistance against that. Now, where it exited, it's still not free to just fly like the one that went through his chest and out the back. It's still semi-trapped between your husband's body and the floor, so that's going to cause even more energy drain until it comes to rest.
And how far away from my husband's shoulder was that bullet fragment found? The projectile, I guess.
When it was found, I don't know the exact measurement away from it. I would say a foot or more, maybe.
Okay, so that's what you're talking about the energy. It still had energy to keep moving. Is
Yes.
that correct?
It had enough to escape from being under the body.
Okay. So because of what you saw at the scene, and you state in your report that it was your suspicion that that's what had happened, was that my husband was supine on the floor, is that correct?
Yes, ma'am.
Okay. So was it your suspicion from the start of this investigation that led you to not confirm any other alternative?
What other alternative, ma'am? My job was to collect the information and put it together with the information that was being collected in the interviews. The information from the interviews did not completely match everything that I had learned at the scene.
Okay. Let's see. You did not test the wood floor, is that correct?
I'm going to object again to asked and answered multiple times.
Sustained.
You did not test the projectile, is that correct?
I'm going to again object to asked and answered multiple times, and I'm going to move to start striking every question.
Sustained.
You did not investigate my husband's shirt.
And object again to asked and answered multiple times.
Sustained.
Did you call Aloha, Carolina, and ask them about the fabric of my husband's shirt?
No, ma'am.
Okay. So would it be fair to say that you made an assumption early on and only investigated the things that supported that assumption?
Ooh, no. Don't ask the ultimate question. That's a mistake, and lawyers make that mistake too. They make that mistake all the time, but it's a tragic mistake. You don't ask the ultimate question because it just gives the person a chance to wiggle out of it. You ask them every question along the way, but you don't ask that ultimate question. So wouldn't it be fair to say that you were assumpted? And no. That's a mistake. Don't do that. It's a mistake every time.
No, ma'am.
Okay. Remember in your report where you stated that the bullet strike to the abdomen had an upward trajectory, passing through the left lung before exiting near the left shoulder.
Yes.
Okay. Could that upward trajectory have been caused by my husband falling backwards and the bullet hitting the abdomen and going upwards and exiting his shoulder as he hit the floor?
No, not in my opinion.
Okay. Detective Coons, on July 11th, 2019, were you at the Chandler Police Department during my interview?
No, ma'am.
Were you there that morning when we were brought into the Chandler Police Department at all?
No, ma'am, I was at the scene.
Okay. I thought you didn't get to the scene until 11:45.
No, that was when we actually obtained the search warrant. It was about a little after 11:45. I was
Okay.
already at the scene shortly after 9 o'clock.
Okay. Did you see the injury on the back of Alex's head with your own eyes?
I did not take a close look at it. I saw the paper towel that he was holding against his head.
But you did not see the wound itself?
No.
Okay. Are you aware if Alex's hands were swabbed for gunshot residue?
There would have been no reason to swab for gunshot residue.
Why is that?
He had already stated that he was the shooter.
He had stated it?
To my knowledge, that's how the information was provided to me.
Okay. Are you aware if my hands were swabbed for gunshot residue?
I am not.
Okay. Are you aware if my daughter's hands were swabbed for gunshot residue?
I am not.
Do you know for a fact that Alex shot the gun in question?
No.
Based on the information provided, that is what I have, yes.
Do you know that for a fact?
Just with the information that's been provided, I can't tell you one way or another if there's another shooter because the evidence does not show that there was.
Okay. So all you really know for sure, after your 5 years of investigation, is that my husband was shot 2 times, 1 by that particular gun, 2 with those particular bullets, at my residence, and that he passed away as a result of that. Would that be correct?
Oversimplified, there is a lot more information that is available to us for that.
Is that correct? Is that question correct?
Well, it's not all I know, so no, it's not
There are
correct.
some known facts, yes, but that is not all we know.
There you go. That's the right answer. Good job.
So you can't really tell me for sure who shot him, can you?
Well, as we've established, I was not present when it happened. I can only go with the facts of what people have said and what the evidence shows.
Okay. You don't really know what time he was shot, do you?
Actually, no, I don't.
Okay. You don't really know if he was falling back or lying supine on the floor, do you?
Yes, I do.
You don't really know what time my husband actually passed away, do you?
No, ma'am, I don't.
Thank you. No more questions.
You know, I have to give her credit. It was surprisingly good. You know, some people said it was disaster fuel and all the rest of it, but I have to disagree. It was not disaster fuel. She did surprisingly good. I mean, it was great. I've seen attorneys do worse. She made a couple mistakes along the way. She was a little repetitive at times, but you know, she did fine. She did fine for her cross. You know, exposed basically any flaw she could find, which is, you know, what a good attorney would do. Try to find any potential flaw. It's like you didn't follow this lead, didn't follow that lead, you didn't investigate the shirt, you know, just basically try to when you don't basically have much, just pick apart the investigation, try to show it to be incomplete or slipshod or that they rushed to assumptions or something. I mean, she's got the right idea and she went about it in a fairly coherent way. I think she did really good. I think she did fine. Not to say that, it's successful in the ultimate, but, for what she's trying to do, she did good. So that's what I have to say about that, man. Surprisingly good. I'm sure the state, is making its case in every way, and the flaws are basically nothing burgers. And of course, the state's going to rebut it on, redirect and, tease out why certain things aren't what they appear to be. But she's trying to do her best to show any weakness she can find. And that's a reasonable strategy. It's a perfectly reasonable strategy. So, points to Lori Daybell, best attorney of our day. Who knew? Well, my friends, I'm going to go ahead and end the stream. This has been fun for now, but we may do some more potentially tomorrow, depending on, what people are interested in, and also depending on my own interest and depending on what else comes on tomorrow. So if you're really interested in more Lori Daybell, please make sure to join our Discord and express your support for more Lori Daybell. And if there's enough interest, then perhaps we'll do that. And in the alternative, if there's something else you prefer us to discuss, then you can, of course, bring that to my attention and we'll discuss that too. And that should be super duper fun. All those things. I've been Uncivil Law. Until later, my friends, I hope you have the greatest of days. Cheers for now, my friends, and goodbye.